financial crisis recovery.
Foreclosure, short sales, bankruptcy, credit card debt, job loss, depreciating home values, money management. Peace of mind when it comes to your finances seems completely out of reach under current conditions, but there is a way to achieve it. For the next 60 minutes, you're going to find out how to cover your assets. Cover your assets.
Something that's the smoking gun. And then, I have to have a frank conversation with my clients. Well, we can litigate this, and there's no guarantee of the outcome. Or you might want to contemplate doing a Chapter 13. Nobody can force anybody into a Chapter 13, and that's that repayment plan that you had talked about before. But at that point, it might be the better option because that's the only bankruptcy relief they're going to get because of what just happened in their case.
Well, we just alluded to this in the earlier segment, and I want you to touch on something you briefly touched on. First off, I want to also say that, remember, the trustee's office, who's overseeing this, is representing the interests of the creditors, and they're looking for money. And if they've missed something and they think that there's money there and they can pull that money back, remember, that's one of the ways they get paid. So that's important to know. But the other thing is when the U.S. Trustee's Office brings an abuse case in your bankruptcy filing, it takes it to another level. What happens there, David?
Well, hopefully you can settle it. Maybe there was some misunderstanding. Maybe you can, give them a whole
settle it, more money.
Well,
right?
unless it really kind of gets into something formal, I typically don't charge my clients extra for that or a whole lot more. It kind of depends on what's going on in every particular case. But once you get into an adversarial position, it's a completely different breed of cat. Most bankruptcies are fairly straightforward. But if they do take that nasty turn, litigation's expensive. Then you're looking, okay, it's not what I said I'd be doing this case for. This is an adversarial proceeding, which is considered a separate lawsuit that springs out of the bankruptcy case. It's not the main case anymore. And it could be with the government through the U.S. Trustee's Office, or it could be a creditor. Either one are fairly rare, but they do come up once in a while. And then you say, well, here's the issues. Here's what I think your potential outcome might be. I can't guarantee anything because nobody can guarantee anything in a litigation context. And here's what I think it might cost, but I can't guarantee it because it might be more. If there's briefs and court appearances and trials and whatever, man, you just really multiplied your cost for doing your bankruptcy case by quite a bit.
Oh, yeah. Man. The thing is that it doesn't happen very often. But see, remember this, you guys. If it happens to you, the fact that it only happens to 3% of the time doesn't mean anything to you because it's 100% in your situation.
Yeah.
And when that happens, you were concerned with scraping up the $2,000-3,000 to do the bankruptcy initially. There are attorneys who specifically represent debtors when there are abuse cases filed, and their retainer fees start at $5,000 and $10,000 just to begin to take that case.
Yeah.
So you got a whole new can of worms, and this is why I said before, you hiring the cheapest attorney on the block who knows just a little bit, just enough to be dangerous about bankruptcy can be exceedingly problematic if you've got even a remotely complex case.
Yeah, you want an experienced practitioner to do the analysis for you, that's for sure. And not every case that I file is necessarily 100% sweet smelling. But my clients want to try it. I will say, well, you can run up the flagpole. I can't guarantee it for you. And here's the thing. You're going to sign an acknowledgement for me, so I've got it in my file that says, these are the issues I've spotted. These are the potential problems in your case. And if it blows up, I told you so. Don't be pointing the finger at me, So, but if you want to take a run on it, sure. If it's completely stupid, I'll let you know, and I probably won't take the case. I'm fairly conservative how I approach my clients' cases. There are other people that really push the envelope. If you like staring at the ceiling tiles at night, those are the good guys to go to, I guess. For me, I think my clients
scared to death of what's going to happen tomorrow.
Yeah. You got at least a 3-month span of no sleep when you're doing that. My clients, I think, do not like to be put in a position where they don't know what's going to happen the next day. They don't know if they're going to get their discharge. They don't know how much money it's going to cost them, even how they can afford it if that's going to come to pass. So. Generally speaking, I'm not a timid attorney. I'm not afraid to try things, but conservative bent typically, there's different things you can do beforehand. And really, it's about, again, having the experienced attorney doing the case assessment so you can deal with the issues too. Because there's a lot of times there's things you can do.
But that's
sometimes
the key
there's
word.
absolutely not, but most of the time there is.
that's the key word, experience.
Yeah.
The other thing that is really important is to know that most of these things that come up, so to speak, they're coming up generally at the creditor meeting or shortly thereafter. And so let's talk about that. When you file your bankruptcy, you file, and generally, if the courts aren't too plugged up, generally within 30 days, you're going to have your creditor meeting, also known as a 341, and that's where you're going to stand in front of a trustee. They're going to ask you questions directly. You're going to give testimony, and that's really the amount of time, the face time that you're going to have. Talk about what happens there and what a person could expect.
Yeah, it's one of the things that evokes the most fear in most clients. I think, oh, do you mean I have to go to court? It's actually not court because there's no judge involved. It's an administrative hearing. But for ease of use and familiarity, we say court. That's the hearing that you attend. It's generally pretty brief, typically, and it's all federal, so you're not going to the local county courthouse or something. Then for cases in the metro here, it's St. Paul or Minneapolis federal courthouse. There's a hearing room set specifically for doing creditors meeting. And what happens is when you file a case, a trustee gets assigned your case and on a random basis. And they have particular calendar days that crop up where they're hearing their cases. And it's, right around 30 days after. I wish I could pick the days, but you can't. You just got to go when it says to go. It's mandatory that debtors appear. We go with them. Your attorney generally goes with you. They actually schedule them, typically 6 to 8 of them on a half-hour block. So do the math. A few minutes apiece is what they're typically allotted. Now, if it's a difficult case or there's issues that crop up, they'll take all the time they need. But most cases don't take too long. Basically, the line of questions is, well, they call your name, we go up front, we show them your IDs and blah, 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 and then they say, what's your name? Where do you live? Did you read and sign the documents? Was everything accurate? Did you list all of your creditors? Did you list all of your assets? Are there any errors or omissions you'd like to tell me or the court about at this time? And so they satisfy those kind of basic administrative statutory requirements. Then they're looking at assets. What do you got? What's it worth? Where do you come up with those numbers? And transfers. Did you sell anything? Did you give anything away for less than it was worth? Those types of things. So that's what they're mostly interested in.
Where'd the money go?
Where'd the money go and what do you got? Can I take something from you or can I take it from somebody else? That's what they're looking for. And typically they say, in my cases, 99 times out of 100, okay, that's all the questions I have. Thank you very much.
Preparation. So let's take our last break. We're going to come back and speak with David Kingsbury from the Kingsbury Law Offices, bankruptcy attorney personified in the state of Minnesota. He is the guy that you want to talk to about doing bankruptcy, or consider it if you like. Also, remember, go to CYA21.com and download the Financial Crisis Bible. Give you a ton of information for free. You got to give up your email to get a book that's going to tell you the stuff you're looking for so that you can be well prepared when you come see someone like me or someone like David, and then get a lot out of that consultation. Let's take our break, and we'll be back on the other side of the break. Welcome back to Cover Your Assets. We've been trying to cover bankruptcy, planning, strategizing, the things related to a bankruptcy. Although you may never plan on filing a bankruptcy, because frankly, nobody ever does. But if you really understand how bankruptcy works, as I always like to say, it is the best asset protection tool you might have if you understand it. But you got to know about these things long in advance. So for those of you who say, I don't need to hear this, I'm not ever going to file bankruptcy, you need to understand from an asset protection standpoint, bankruptcy and the rules and the exemptions that guide it really can be your guide when it comes to creating an estate and asset protection plan. And understanding the ins and outs should you ever wind up there is vitally important. Then, of course, if you are considering it, then you really need to know this. Now, the last thing that I want to cover before we wrap up the show is the pre-planning and the understanding of how bankruptcy and divorce need to be planned and intertwined, and people just simply don't know this. So let me give you an example. Number one, you and your spouse, when you get divorced, may have marital assets, and you may also have marital debt. So if you both are on a credit card and you file bankruptcy and your spouse does not, okay, great. You got a credit card with $30,000 of debt on it. You file bankruptcy, you discharge your debt, and you're no longer obligated to repay your creditors. However, you have obligated to your spouse that you are going to pay 50%. There's a hold harmless clause where you can't beat up your spouse's credit. You file bankruptcy on the debt. Now your ex-spouse brings a case against you because you beat up their credit and you're obligated to repay the debt, and your bankruptcy accomplished absolutely nothing. Wow, that'd be kind of good to know before you did that. Another thing that's very important is, what if the median income test, meaning the maximum that I can earn as an individual filer in bankruptcy, is $47,000 a year approximately, and I make $60,000 a year. But as a couple, we can qualify for bankruptcy if our combined income is, I believe, $63,000 is the new number, if I'm not mistaken.
Roughly, yeah.
Yeah. So hey, I'm good. I'm in great shape. Well, no, you're not, because if your spouse doesn't work and you get divorced, now you earn $60,000 a year. Your spouse earns nothing. He or she qualifies for bankruptcy, and now because you're an individual, no longer a couple, you don't qualify, and your spouse can discharge the debt, and you're still on the hook for it. And granted, you can pursue your spouse for it, but what if your spouse has no money and is non-collectible? So there's a lot of implications related to bankruptcy and divorce, and ironically, generally, bankruptcy attorneys and divorce attorneys don't talk. So, David, talk about that a little bit.
Well, you started at the top of the segment with saying, you may not ever think you need to do this, but life happens. Divorce happens. And frankly, divorce and bankruptcy kind of march in lockstep quite often. Used to be, people, when they're getting divorced, they're splitting up property. These days, the question is, who's going to take this debt? Now, because that's really all we've got, So, and what a lot of people don't understand, it's much to their chagrin when they come in to see me, they say, well, my husband, it says in a divorce, he has to pay it, or it says my wife has to pay it. That's between you two.
Not the creditor.
It doesn't go up. It's a lateral thing. It's between you guys. So the creditor's going to say, I don't really care what your divorce decree says. You owe me, and you're going to pay me. And that's a problem. Now,
and most of these debts are joint and several, where each person can be held 100% responsible.
Yeah, sure. Oh, yeah. Then you can't say, I only did half of it. They're going to say, oh, too bad. Joint and several liability. We're going to get it from wherever we can get it from if you're collectible. That's the problem. What a lot of people don't really understand.
Go. We're running out of time.
We're running out of time. Is that if you get ordered to pay debt in your divorce decree, if it's joint debt, it is non-dischargeable in bankruptcy, just like if it was child support or maintenance obligations. And you're going to get stuck with it no matter what. And that's a situation where we may be looking at doing a different kind of bankruptcy for somebody. It's treated quite differently.
Pre-planning. Listen, thank you all for listening. Hope this was valuable to you. Go to the Financial Crisis Bible. Download your free download. Thanks for listening. We'll be back next week talking with tax. Ran out of time.
The proceeding was a paid program. The views expressed are not necessarily those of the management or ownership of 1500 ESPN. ESPN Radio Sports Center. I'm Kevin Winter. Michael Phelps stole the show at the Olympics 4 years ago in Beijing as he won a record 8 gold medals, and now all eyes are on him once again in London, and so too is the pressure. 7 events this time around. His first 400-meter individual